So at one end of the spectrum, absolute discretion is problematic. At the other end of the spectrum, no discretion is equally problematic. And it strikes me that there's been no attempt to find a balance in the middle.
The concept of psychosocial risk is far from new, but the dialogue and industry discussion about the topic has elevated since regulatory changes were announced in 2023 and 2024. Psychosocial risk is now the focus of many conversations in the corporate world, from boardrooms to executive teams, and of course through to the practitioners on the ground, trying to join the dots to have meaningful impact. I'm Kate Connors. I'm a master's qualified psychologist, and my professional purpose is to help people and workplaces be at their best.
And I'm Greg Smith. I'm a lawyer who's spent more than 30 years practicing in the areas of employment law and workplace health and safety. I'm also the author of several books, including Paper Safe and the recently published Proving Safety.
And you are listening to Judgmental, when a psychologist and a lawyer walk into a barside chat about psychosocial risk. A big thanks to our sponsor, EML. EML are Australia's largest personal injury claims provider, providing claims management services to workers' compensation, life insurance and CTP markets, with the purpose of helping people get their lives back. We have another jam-packed episode today, so grab a drink and sit back for another discussion at the bar. Hello listeners, and thank you for joining Greg and I in the bar again today, whatever time of the day or night you might be listening and joining us. Before we kick off, my name's Kate Connors, and I would like to begin by acknowledging the traditional custodians of the lands that I'm on today for this conversation, which is the lands of the Wiradjuri people of the Kulin Nation. And I would love to welcome a hello to Greg Smith.
Hello, Kate. Nice to talk again. Today I'm up in Perth, so I'm on the land of the Whadjuk people of the Noongar Nation. And so what can I get you, Kate? What do you feel like drinking?
I think it might be a Chardonnay conversation today.
Chardonnay. Oh, God.
Chardonnay? Not a West Australian Chardonnay. Too woody and oaky for me. Prefer a bit of a cool climate one, so maybe from around, where would it be? Around Albany?
Oh, yeah.
And Denmark? Pemberton, yum.
Crimbers do good Chardonnays. All right.
Drinks are on you today, are they then, Greg?
They are. What are we talking about today, Kate?
What are we talking about today? Well, this is one of the ones that a decision you wanted to talk about, which I think is a really interesting case, decision that came from the Fair Work Commission.
Yep.
So it's an application for unfair dismissal.
Yep.
Is the situation. And it is a really interesting decision to unpack psychosocial risk from a sense of an employer having the same responsibility to multiple parties, and how that plays out.
I think this is a conversation you and I have been having for a long time about how do we manage that intersection of legal risk management and psychosocial risk management and people management and all of those things. So, all right, well, perhaps we'll start. I'll give a rundown of the case. This is a decision involving a fellow called Mr. Zoran Mojanovski, I think is how you pronounce it, Mojanovski, and Blue Scope Steel. It's a recent decision, a 2024 Fair Work Commission decision. We will link the case in the show notes, but for you case authority nerds out there, it's 2024 FWC 1473, if you're really keen. So just a brief synopsis of how we get here. So we're talking about a long-term employee who'd been involved. There'd been no disciplinary action against this fellow before September 2023. And then in July 2023, there was an anonymous complaint made. And I think this whole idea of anonymous complaints creates some interesting issues in the context of these sorts of things.
Totally agree.
So there was an investigation into various complaints, several of which were found to be substantiated, and they involved sort of abusive, threatening and intimidating behaviours. And as part of that, Mr. Mojanovski had to undergo refresher training around bullying and harassment and the company's code of conduct, the sort of stuff that's pretty typical in these cases.
Yep.
I won't dive into it here, but it's probably worth having a look at. There was some criticism of the original investigation, and I think we'll probably come to it, but one of the things about these cases is they do highlight the importance of quality incident investigations and proper procedural fairness, and that's always been the case in the Fair Work Commission. But then in January 24, we get another complaint. It's not an anonymous complaint this time, but the complainant's identity is kept from Mr. Mojanovski. The complainant provided a statement. They weren't formally interviewed, which is interesting. That there's a comment in the case that the company thought they had all they needed based on the statement.
Yeah.
Which I think is a bit problematic if you're not going to test the veracity of what complainants are saying, particularly in this case because the applicant, Mr. Mojanovski, he denied what was described in the complaint. He said it didn't occur and there was no evidence of what had occurred. So they looked at some CCTV footage. They couldn't find anything on there that helped. They spoke to another person who was in the area. They couldn't help. But on the strength of that, and again, there were some criticisms of the investigation in the case, Mr. Mojanovski had his employment terminated and he brought an unfair dismissal claim. Now, the crux and the interesting point in this claim, it was very difficult for the employer to defend, partly of their own volition, I think, because they didn't require the complainant to give any evidence at the hearing. Now, this part of the case, again, it gets a little bit messy. There's evidence and criticism by the Commission of one of the people investigating the claim changing their evidence, sort of from the complainant not wanting to be involved to a sort of company decision to protect the complainant.
Yeah.
Whether the truth lies in between or not, it doesn't really matter ultimately. But it's clear from the case the complainant did not give evidence. And it seems, I think, on balance, the reason why that the employer didn't compel the complainant to give evidence was that they were concerned for the well-being of the complainant and they kind of wanted to protect them. And there's an interesting thing that sits under that I'll come to in a moment. But it's fair to say the Commission was critical of this stance. They said at paragraph 47 that the complainant was clearly available. He simply chose not to be involved and the respondent chose not to seek to compel them to give evidence, citing, and this is an interesting comment, citing a claimed duty of care to the complainant. And they also noted all of the contacts between the complainant and the people involved were by telephone and no medical certificate was sought to sort of suggest that they were incapable of giving evidence, which was interesting. Now, what really becomes fascinating is that the applicant, so Mr. Mojanovski, was successful. The termination was overturned. He was found to have been unfairly dismissed. And probably most importantly in the context of the case, he was reinstated back into the workplace. Now, I don't know if he ended up back in the workplace or if the company paid him out to try and resolve it. I don't know. But I just want to touch on two things from the court before I open it up, I guess. Paragraph 68. The court said that clearly if the allegations had have been proven, they would have been serious breaches of the code of conduct and the various guidelines that the company had.
Yep.
But they said there was a complete absence of evidence before the Commission to substantiate that any of the alleged threats were made. And the Commissioner said that they found the applicant, Mr. Mojanovski, to be consistent, considered and compelling in his denial of the allegations, and consequently found that there was no threat of physical violence towards another employee and therefore no valid reason for the termination.
Yeah.
Fascinating. So before I throw it to you, Kate, for your thoughts, from my perspective, the case is really quite unsurprising.
Yeah.
If you're going to make allegations and terminate somebody's employment and that's challenged, you're going to have to bring some evidence to show why it was done. But it highlights, I think, two problems, and they are problems that have always existed in this area. But I think in particular changes to the WHS legislation have made it a little bit worse, and we'll come to that. But first of all, how do we balance the rights of all parties to a complaint, particularly if you do have a genuine concern for some of the people involved? And the other interesting one, because I'm living through this at the moment in something that I'm dealing with, is how do you manage the expectations of a complainant who does not want to be involved beyond making the complaint? What does that look like? So as a non-lawyer, Kate, you've had a read of the decision.
Yes.
What are your thoughts?
There are a few things for me that came up as I was reading the decision. And probably the first one that came up, if I think about things that came into my head as I was sequentially reading over the decision, was, hang on a second, it feels like not feels like, basically the case decision documented that the allegation was substantiated before having spoken to the person who the allegation was about. Like, that was essentially how the case was presented.
Mm.
And at a psychological level, straight away as I read that, I thought, oh, I wonder how the applicant felt about that. And at that point, as you're reading the decision, you're actually not really clear about what the actual application is. But then it became clear in the way that the decision was handed down that that was a really relevant point. And so I thought that was interesting in this kind of context of the intersection of procedural fairness from a legal perspective with the human nature requirement of wanting to be heard.
That's doubly interesting because one of the other cases we're going to look at is the Vision Australia case,
Yeah.
where a worker who was unfairly dismissed without proper fairness actually suffered psychosocial harm and sued the employer.
Because they weren't.
But
Yeah, exactly right. And so I thought that was the first thing I noticed as I read over it from that psychological overlay. The other thing, well, there are a couple more. One was the fact that it was a long-term employee. And Greg, I was curious in terms of what's typically in decision, all of the paperwork or all the documentation of a decision. But in my view, I was curious to understand, well, if this guy's been employed for, 20, 30 years or whatever, and there's never been any issue, what's changed?
Yep.
And when were they asked about that? When was there any, kind of curiosity on the side of the employer in terms of what's happening here? Like, why is this behaviour, which the way that the behaviour that was alleged was documented was serious and gross misconduct. I don't think anyone would doubt that. But therefore, why is this happening? Like, what's going on for this person if it had been substantiated? And how relevant is that in the context of these kinds of decisions?
that's a fascinating point. So if we're talking about it purely from an employment law perspective, being a long-term employee is a relevant consideration that the Commission takes into account in deciding whether a termination is unfair or not.
Yeah.
But, and I know you've mentioned this before, but it's interesting how many times you've talked about this, and it just never clicked to me looking at this decision, this idea that we have a long-term employee who we've not had problems with, or at least on the face of the case.
Yeah.
There may have been problems that just weren't part of it. But this idea, and you talk about this a lot, where you have a long-term employee and suddenly, which appears to be the case here, something's changed in their behaviour. So if we have a genuine concern about psychosocial well-being in our workplace, that should actually trigger some curiosity on the part of the organisation to say, oh, has something changed in this person's life?
And what is happening for that person so that we can more fulsomely support as well as understand and, I don't like the word, but I know it's relevant, investigate what has happened to you, right? To be able to make a fair and just determination at the end of it. That's, as a psychologist, how I would think for the person themselves it would feel procedurally fair.
Yep.
Yeah.
But at the same time, conscious that you've got a complainant who's, right, yeah, so
It's experienced something that was very distressing, again, on the face of what has been detailed.
yeah.
I think the other couple of points that really stood out to me was this one around confidentiality, Greg. Oh, my goodness. And within HR processes,
Yeah.
the process promising confidentiality, I just don't understand where in any of the legislative framework or regulatory framework that HR people operate within that people can promise that.
Yeah, I think that's always been an inherent weakness. And we see it all the time also in health and safety investigations where people promise, this won't go any further. Da, da, da. And you're right, that's a promise you simply can't make. And particularly in the case of sort of psychosocial complaints now, that's probably become even more exacerbated because there's certainly an onus on the organisation to investigate it.
Yeah.
So it's very hard to say it's not going to go any further. And in many cases, there is now obligations to report the behaviour to a regulator. And that's one of the points I was going to come back to. So we might just hold on that for now.
But I think that also has, in my view, it kind of has tentacles out more broadly into the psychosocial risk, broader frameworks in regards to not only process and what's promised in process, but what that culturally creates within an organisation in terms of a lack of trust and what that means if you work somewhere and someone has promised something, particularly someone from the HR team promising something that can't be delivered on, and therefore what that means for this broader speak up movement. Can you call it movement? I don't know what you call it. But the priority around creating psychological safety in workplaces and I don't know, just the infrastructure around that not actually being what it needs to be for that promise to be real.
Which I was going to come to it later, but it's on point now. I mean, one of my concerns about, I'm not trying to sound dismissive of this, so let me start by saying I fully acknowledge that psychosocial well-being is an important issue and it's got a real life of its own and a momentum at the moment and does need to be taken seriously. Okay. And I also accept as a matter of principle that work plays a significant role in people's mental health and well-being, and that mental health and well-being is a workplace health and safety risk. I fully accept that.
Yeah, I know you do.
I have no problems with it being dealt with by work health and safety legislation. It's just that the framework for this particular risk, as we talked about in the paper on risk assessment we discussed, where the model of risk assessment is not suited to psychosocial risk, the whole framework of work health and safety doesn't seem to be suited to psychosocial risk. So, for example, and I don't know where the balance is, and I'll be interested in your view, the idea that if somebody brings a complaint, the organisation loses or almost has no discretion in how it responds. It's got to investigate, it's got to review its systems, and in many cases, it's got to report.
Yeah.
Which once I think that starts to become ingrained, that's going to be a real disincentive.
Absolutely.
For people to raise these issues. Now, I accept that having a complete discretion is problematic as well. And we've seen that over the years with particularly sexual misconduct cases not coming to light and people being moved on and payouts done and offenders moving around. This was a particular issue on mine site that they talked about in the Enough is Enough report. So at one end of the spectrum, absolute discretion is problematic. At the other end of the spectrum, no discretion is equally problematic. And it strikes me that there's been no attempt to find a balance in the middle.
And I think that you're right. And I think that part of what I see in this decision, or what's played out in terms of what's documented in the chronology of the actions taken, to me speaks to this broader point around the need to improve psychological literacy through the process thinking, right? Is, again, when I read that decision and it was around the complainant saying, oh, I'd prefer not to, like, give evidence and I'd prefer not to, was the quote or something, wasn't it? Something like that. It's kind of protected from a sense of let's be trauma informed. Like if someone doesn't want to be involved, then we need to honour that. I kind of get that at one level, but I also think that it's almost like a blunt instrument in applying a trauma-informed intent in that way, because it's very all or nothing, and it doesn't need to be all or nothing.
So how do you guide an organisation through that difficult position?
Yeah, to me, this is about where does an organisation have access to the right expertise to help to navigate with the person and co-design with the complainant how the process is going to be timed, how the process is going to be supported, how they feel in control of how they give the information that the organisation needs to hear from them, how they feel as safe as possible, right? And I think it's really interesting to apply that with the lens of what we talked about in episode 2 in regards to the psychosocial risk 3 steps of psychosocial assessment, because it's not an all or nothing application in physical risk management.
Yeah.
just the same way that it shouldn't necessarily be an all or nothing application in psychosocial risk management. So whereas I think because people are so scared of it and because they don't have the understanding and they don't have the expertise and their psychological literacy is low, that it's just, well, let's just not touch it at all. Let's just go. And it really just doesn't need to be that way. There's more nuance attached to it that you can't put in a checklist and you can't put in a process document, but you would, if you have the right expertise advising, be able to co-design something.
Yeah. I'd be interested in your views on this, Kate, because it strikes me that, one of the real opportunities to mitigate a lot of the problems that came out in this case was to properly investigate the complaint with the complainant. Like, that wouldn't have exposed the complainant to the person they're complaining about, but, to properly explore and test their evidence effectively, to test the case. And now you could do that with support, but that doesn't put the person, I suppose it depends how you do it. I mean, if you're coming at it from a position of, I don't believe you and I'm going to test this, then that's hugely problematic.
Absolutely.
Which is kind of what's the reverse of what's happened in this case. They didn't believe.
Yeah. And so it was the all or nothing approach that weighted a bad outcome. And so I think any all or nothing approach is not going to serve the broader outcome that people are trying to achieve. And I think that is inherently the challenge in navigating psychosocial risk, is that people want, you've talked about this a lot. They want the checklist. They want a process. They want to know, how is it that I scale this up? How do I make sure that this is being applied consistently?
Yep.
Because that's the safe system of work kind of intention, yeah?
Yeah.
Your outcomes are only as good as the systems that you put in place. But whereas I think a safe system of work is, well, let's get the right person with the right expertise in to advise and case manage and help us nut this through. Because there's going to be nuance and there's going to be individual difference. Again, when we go back to what's different in terms of psychosocial risk, in terms of the assessment of harm as well as the assessment of hazard, there is individual difference in terms of what is hazardous and what is harmful. And so you need to be able to have those conversations at a deeper level to assess the risk. And there was no risk assessment done here in terms of, would it be hazardous and therefore would it be harmful for the complainant to give a statement or to come and give evidence? There was no risk assessment of that.
No. And I don't think the Commission obviously didn't put it in those words, but I think that's kind of what they were getting at when they said, well, there's no medical evidence.
Medical evidence, yeah.
So what's the issue here?
Yeah.
I think that's right. I think where larger organisations in particular seem to be overly biased towards the complainants. And I kind of get that. I'm not saying that's necessarily wrong, but I think having a balance one way or the other is just unhelpful. You have to take everything on its merits when it arrives at your doorstep, don't you?
Oh, absolutely. And just to be the voice of the person who is accused of something. And in my career, I've done a lot of support for being a support person for the person who has been accused of, be it bullying, be it sexual harassment, but accused of a behaviour that would be defined as gross and serious misconduct. And people who are accused of those things have very complicated psychological reactions during those processes, and I think still deserve to be treated humanely.
It's interesting, Kate, because just as you're talking then, because I've seen a lot of psychosocial risk registers over the last 12 months and lots of procedures being built around this, none of which raise the issue of either false complaints or the potential, what do we do to mitigate the risk of the person who is being complained about?
Yeah.
And presumably, if we've got a psychologically safe workplace, that would be a factor we'd be thinking about, wouldn't it?
You would hope so, if people are also talking about a culture of care and a genuine sense of well-being for all people. timeliness with which the timeliness, oh my goodness me, the amount of time that these investigations are taking, that in and of itself, in terms of psychosocial risk for the person who is accused of behaviour, is inhumane. Like, honestly, it is unbelievable.
And often sent home, stood down, sent home on full pay.
With no communication,
Yeah.
no understanding of where the process is at, with no touch points in regards to how are you? Like, we know that this is difficult. Like, it's really, really appalling what is going on in regards to organisational injustice. And ultimately, let's also label what this is in terms of a psychosocial risk. The psychosocial risk for the person who is being accused is organisational injustice, is the risk that they are being exposed to. Can they trust the process that is unfolding? And that is very profound.
There's a much deeper conversation here, and I think it'll probably filter through the rest of our episodes. But I think at a fundamental level, there is a distinct difference between fairness and justice on the one hand and procedural fairness on the other, because I think we often, and socially, I think we equate following the process with achieving a just outcome. And I don't think that's just right. The fact that we create a bureaucratic process and we follow that and says this interview happens and then this report happens and then this happens and then this happens, and we just follow that mechanistic bouncing ball without actually genuinely considering the well-being of the people in the process, seems to me to be an issue.
Well, I think it comes down to the design of the process.
Probably more the skill set of the people involved, though, isn't it?
Well, probably a bit of both. I think the process itself can be designed acknowledging the importance of expediency, whereas I rarely see that. And I think, to your point, it is that the sense is that thoroughness and, it just takes time to ensure, or people thinking that creates a more likely to create, a more just outcome, seems to be where things are loaded, versus it is really important that we do this as quickly as possible. But that doesn't necessarily, and that then comes down to a supply chain point in regards to what providers are being used in terms of the workloads of those providers, how available they are for interviews, and all of those kind of tactical and logistical points.
I mean, yeah, the biggest issue I see in those areas is often when you will have one or more parties to the complaint who will go off on some form of sick leave and not participate in the investigation and continually put off participation. Then that creates a whole different process.
Well, you know what? That might be a good segue into another reflection that I had about this, which I think is one I'm a little bit nervous to say publicly. But I'm going to put it out there anyway, because there is something about this decision that for me also triggered me thinking about the processes that are in organisations at the moment, almost like de-adulting conflict. And ultimately, how do organisations create cultures that are genuinely psychologically safe, that are founded in the concept of we speak to each other about things? Now, that's probably a big, it's a long kind of leap away from the substantive matter on this complaint. Do you know what I mean? But that did trigger in my mind this broader area of when there is conflict or when there is a grievance interpersonally, how those things are handled by organisations. And it's an issue.
I was talking to a teacher last night and she was telling me about, she's aware of some problems at a school and the sort of immature behaviour of the adults avoiding each other, and then the leadership of the school not bringing the adults together. And she says, we model the type of behaviour we expect with our children all the time. When somebody says, he hit me or she hit me, we bring them together and we sit them down and we say, right, tell us what's going on. And yet that's the behaviour we expect from, grade 2s and 3s, and we model that in the schoolyard all the time, and yet we can't get adults to sit down and talk to each other respectfully.
Absolutely.
Yeah. Entirely different area where lawyers probably shouldn't be involved in that conversation. But this is the transdisciplinary issue, isn't it? About how do we bring those different points of view together?
And also, how do we acknowledge that there is so much individual difference in the level of comfort, the level of capability that adults in a workplace have in regards to feeling like they can raise something with somebody,
Do you think that's where organisations and people take so much comfort from things like a grievance procedure? Because they can say, oh, it's now a grievance procedure, we follow this process. And all of a sudden, you don't have to bring any of that thought. You just don't have to think or cater for a difference.
Absolutely. But I don't think that there would be many people who would then say that the outcome is good from that. That people are then feeling more comfortable with each other. They've had a chat about something that's gone on. Like, soon as you enter those formal processes, the outcomes are kind of set, really. I mean, I haven't actually seen any research that speaks to that, but I think that that's at a practitioner level in terms of what I've observed. And like it just doesn't, like, I'm quite proud of looking back over my career and thinking about the times when I've been, in pretty awkward conflict, and now, fine, mates, can speak to people, etc. There's always a time where it's just like, yeah, no, it didn't work out that way, and that's a shame. But and I think all of us have got those things in our work history. The longer that you're in a workplace, that you come across, you just, I don't really get along there. That didn't go well. But I just don't think that the way organisations are structuring themselves, or again, this idea of, or the psychological literacy level is high enough such that people can exercise judgment. And I think that's the key point that is missing in this conversation, is making a judgment call rather than, because you don't feel like you can make a judgment call, you rely on a process.
I think the two observations I'd make about process is, one is, from a HR perspective, when we're talking about these types of issues, my experience is once you trigger a process, there's going to be a winner and there's going to be a loser.
Yeah.
That's pretty typical. But to your observation there about the outcome, I think, and this is part of the bureaucracy and institution of large organisations, a good outcome is a successfully followed process. That's how we often measure the success. We say, yes, our process was correctly followed. And that's often a good defence in legal proceedings as well.
Oh, sorry. If there was a video to this, people would see me sitting back in my chair with a right grin on my face, because that is just not how I would think. Not how I think at all, which I think is of this podcast, isn't it? Like, I just kind of sit back in almost abject horror at thinking that is the definition of a successful outcome, whereas in my view, the definition of a successful outcome would be that two people feel as though they understand each other's perspective, have a greater level of awareness about how they've contributed to something, and a mutual sense of, what would be the right word, understanding has been achieved and agreement on the way forward has been achieved. That would be my sense of a positive outcome in.
But then there's this logistical dilemma of, how do we deliver that level of counselling or mediation into an organisation, as opposed to, here's the procedure, follow that.
Takes leadership, Mr. Smith.
We're
a cultural commitment from the very top that this is how we want our workplace to feel and to be. And if you want to be part of this village, this is our commitment to each other, and it's going to feel uncomfortable at times, but we will support people in that sense of discomfort, because we know that that's going to create a better workplace, better outcomes. And what we're looking to do is to create that rather than to create adversarial commitment to process where there's a winner and a loser. And right, and some.
All right, so this is the first of our legal cases. I think by the time this goes out, it'll be the first of the legal cases we've discussed.
Yes.
And straight away, we're starting to pick at the scab of this intersection between safety, employment, genuine personal well-being. I'm sure we're going to get some workers' comp
Yeah.
that bubbles along. And just as, by way of a recap, we had a worker who was terminated for alleged serious misconduct. The complainant didn't want to give evidence in the proceeding, so the whole thing got overturned. The unfair dismissal was overturned and the worker's reinstated. So it's clearly a process issue to be thought about for managing these types of cases. But Kate, before I sort of wrap up, from your perspective, key takeaways. If I'm an employer, I'm listening to this, what are my key takeaways from a psychologist's perspective when we think about a case like this?
I think the first one is around don't promise what you can't deliver, which is around this point around confidentiality. There is no quicker way to breach trust and to create underlying psychological harm than promising something that you can't deliver on. So that would be one. I think the next one is to do with this idea of reviewing how organisations are executing on creating a speak up culture and making sure in that you're reflecting on, are we creating that in a way that means that people can sidestep speaking to each other?
Yep.
And what the longer term impact on that culturally might look like. And then I think the third one is not seeing being trauma informed or human centered as a one size fits all. Like, it requires nuance, it requires conversation with the people that you are wanting to protect. And it doesn't necessarily mean that it needs to be no exposure at all. It can be co-designed in a way to help it still feel or be safe, even though it might not necessarily feel comfortable.
Okay, thank you.
What are yours?
Two I thought about before and one that I think you've given me. I think the thoroughness of your inquiry/investigation processes is paramount from a legal risk management perspective. You don't get to take shortcuts, even if people don't want to be involved in the process. You need to be as thorough as you can in terms of how you investigate, how you put accusations to people, how you assess evidence, and how you form views. You have to be very thorough around that. I think a second important lesson is just because a person doesn't want to be involved having made a complaint, that's not an automatic Barleys, I'm not involved anymore. I think organisations need to properly test the reasons for that and be comfortable that there are legitimate reasons and be open and honest in explaining what the consequences of that position are. And it goes to your point, Kate, of the trust issue, to be open and honest to say, well, A, if you don't get involved, there may be limits on what we can do, if anything, and B, it may get taken out of our hands if we need to report it, and there are things that we have to do. But the third thing I'd say, and this is as much a reminder for myself as I think a practical takeaway, is if you're dealing with a case where a worker is suddenly exhibiting behaviours that they've never exhibited before, be curious about that and ask some questions and see if there is a problem that the organisation can help with. That's where I'd get to.
I think they seem like good takeaways. And maybe the other one that I was interested in your reaction when I said this was also around the duty of care to the person who has been accused of something.
Yeah.
I think that was an interesting reaction that we both had in that moment of the conversation, which, when people are at their worst and they have done something that they're not proud of, doesn't mean that they don't deserve to be supported as they were that through.
Yeah. You can support people while still acknowledging you've done something wrong and there are going to be consequences.
Yeah, absolutely.
Yeah, I think that's right.
Well, thanks for that. That Shardy was good. Thank you, Greg. I appreciate that.
Very much. And we'll look forward to catching up next time.
Yeah, thanks for joining us in the bar, everyone. And see you in the next episode, or thanks for listening.
Thanks for all listening. Bye.
That's a wrap for another episode of Judgmental. Thanks again to our sponsors, EML. EML's Mutual Benefits Program provides organisations with free services, tools and resources to manage their workplace risk. You can follow EML, myself and Greg on LinkedIn. And be sure to check the show notes for links to the papers referenced in each episode, as well as resources available to help you as you navigate the wonderfully complex and nuanced world of psychosocial risk. See you again next time at the bar.